Hello friends, in the series on the income tax cases, today we will discuss a very important issue. The issue in the present case before the Indore I.T.A was that if a notice under section 148 has been issued to a person who was already died before the issue of that notice, and during the assessment proceedings it was duly intimated to the AO that the person to whom the notice has been issued is no more, and even then the assessing officer completes the assessment in the name of the dead person. So whether in that case that assessment is valid in the eyes of law, this issue has been taken up by the Indore I.T.A in the case of income tax officer versus Ramesh, Kumar, Sahu, and this case is reported in 126 I.T.A Tribunal at page number 702, and the date of the judgment is 28th July 2025. The present case relates to the assessment year 12-13. During the financial year 2011-12, that is relevant to the assessment year 12-13, the assessee has sold an agriculture land for a sale consideration of rupees 2.39 crore. The assessee has not filed his regular return of income, so the notice was issued to the assessee that the assessee has not filed the return and the assessee has sold some property, so there may be some income which has escaped assessment. So to assess that income, the notice was issued. In the present case, the facts are like this, that the assessee has already died on 19th/11/2017, but the notice to the assessee who has already died issued on 26th March 2019, that is after the date of death. When the legal heir of the assessee got to know about this notice, he through a chartered accountant, that is authorized representative, and by filing the power of attorney, intimated to the learned assessing officer that the person against which the notice has been issued is already died, and the death certificate was also attached. So the proceedings which have been initiated are not valid in the eyes of law. The assessee, the legal heir of the assessee, also intimated on 18th November 2019 the same fact, that the assessee is no more, and again attached the death certificate. But the assessing officer, for lack of response from the assessee, completed the assessment under section 147 read with section 144, that is the best judgment assessment in the name of a dead person. The legal heir do not have any option other than filing the appeal before the CIT appeal, and when this ground was taken before the learned CIT appeal that in the present case, since the assessment has been completed in the name of a non-existent person, so the whole proceedings do not have any validity and null and void. When the CIT appeal heard the matter, he was with the assessee and said that in the present case, the fact is very clear that the notice has been issued after the death of the assessee. It was duly on the record of the assessing officer that the proceedings which is going to complete are not valid in the eyes of the law, because it is based on a notice which was issued after the death of the assessee, and the death certificate was on the record of the assessing officer, so the assessment proceedings are bad in law. The revenue filed the appeal before the tribunal, and when the tribunal heard the matter, the tribunal said that in the present case, the view taken by the CIT appeal is correct, and in the present case, section 159 subsection 2 clause B was available with the assessing officer, which says that if any proceeding can be taken against a dead person, the same proceedings can be taken against the legal heir. But in the present case, the revenue did not opt for that option, and in spite of taking the proceedings against the legal heir, the assessing officer completed the proceeding against the dead person. So in the present case, the whole assessment proceedings are bad in law and are liable to be quashed. Friends, sometimes the question arises that in the present case, the assessee has not informed the assessing officer after the death of the assessee and before the issue of the notice under section 148. That doesn't matter. If the notice has been issued to you and you intimate the AO that the person is no more, so after that also the proceedings cannot be completed in the name of a dead person. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Income Tax Officer versus Ramesh Kumar Sahu, and this case is reported in 126 I.T.A. Tribunal at page number 702, and the date of the judgment is 28th July 2025. Thank you, friends.